Hi, hello, welcome to US Immigration webinar every Wednesday 6 p.m. Central Time with Burgos Law firm Attorney LUCAS GARRITSON. So last week, yeah, a bit busy. It did not happen to make a live. This week we are coming with good news and more information, and it's really good news for green card holders. We see pretty skyrocketing movement. We'll get no more information, the May bulletin and fiscal year 2022 H1 cap and also
ఉపదేశ గ్రంథాన్ని మనం చెప్పుకుంటూ ఉన్నాం. ఇందులో ప్రధానమైన ఉపదేశం భజ గోవిందం, అంటే గోవిందుని భజించు. ఇది చెప్పదలుచుకున్నారు. ఒకసారి చెప్పడం కాదు, ముమ్మార్లు చెప్తున్నారు ఇక్కడ. అంటే త్రికరణ శుద్ధిగా గోవిందుని భజించు, అది తప్ప మరొక మార్గం లేదు. ఇది సరిగ్గా భగవానుడు గీతలో 11వ అధ్యాయం చివరిలో చెప్పినటువంటి మాటే. భక్త్యా త్వనన్యయాశక్య అహమేవం విధోర్జున జ్ఞాతుం ద్రష్టుంచ తత్వేన ప్రవేష్టుంచ పరంతప. భక్తి తప్ప మరొక మార్గము లేదయ్యా. నన్ను తెలుసుకునడానికి కానీ, నన్ను అనుభవించడానికి కానీ, నాలో ప్రవేశించడానికి కానీ భక్తి తప్ప మరొక మార్గము లేదు అన్నారు. భక్తి అన్న భజ అన్న ఒకటే. భజ అనే ధాతువు నుంచే భక్తి అనే శబ్దం ఉత్పన్నమైంది. అంటే భగవద్భక్తి కావాలి. భగవద్భక్తి అంటే భగవంతుని ఆశ్రయించుట, పట్టుకొనుట, తదేకమైన ప్రేమనిష్టతో ఆయన్ను కొలుచుకొనుట. అయితే నిజ జీవితంలోకి వచ్చేటప్పటికల్లా మనం ఏం చేస్తున్నాం? భగవంతుడిని భజించడం లేదు, భగవదన్యమైన సంసారాన్ని భజిస్తున్నాం. కనుక సంసార భజనం మాని భగవద్భజనం పొందాలి. అది పట్టుకో అంటే ఇది వదులుకోనే అర్థం. అయితే ఇది ఎలా వదలాలి, అది ఎలా పట్టుకోవాలి? ఎందుకంటే అది పట్టుకో అని చెప్పారంటే అర్థం ఏంటి? ఇంతవరకు పట్టుకోలేదని, అది తప్ప మరేదో పట్టుకున్నామని. ఏదైతే నువ్వు పట్టుకున్నావో అది నిస్సారం, ఏది పట్టుకోమని చెప్తున్నామో అది సారం. కనుక నిస్సారమైన విషయముల గురించి ఆలోచించి వీటిపై వైరాగ్యం కలగాలి. అందుకే ఈ స్తోత్రం యొక్క ప్రధాన ప్రయోజనం వివేక వైరాగ్యములు కలిగించుట. తర్వాతి ప్రయోజనం భగవంతునిపై భక్తిని నెలకొల్పుట. ఎందుకంటే భగవంతుని భజించడం కంటే మరొక మార్గం లేదు. ముందు భగవంతుని ఆశ్రయించినప్పుడు ప్రేమగా శ్రద్ధగా ఆయన కొలుచుకొనుట, ఆయన మహానుభావుడు మహాత్ముడు అనేటువంటి ఆశ్రయం, ఇవన్నీ మొదట ఏర్పడతాయి. క్రమక్రమంగా భగవంతుని ఆత్మకు అభిన్నముగా అనుభవానికి తెచ్చుకోవడం అనేది జరుగుతుంది. మొత్తానికి ఎలా చూసినా భక్తిపరంగా జ్ఞానపరంగా కూడా భజగోవిందం అనేది సరిపోతూ ఉన్నది. ముందుగా భగవంతుని ఆశ్రయించడం, భగవంతుని ఆత్మగా గ్రహించడం, ఈ రెండు భజ అనే శబ్దానికి ప్రధానమైనటువంటి విషయం. అదేవిధంగా కాలబద్ధములైన కర్మల్ని పట్టుకు వేలాడడం కాదు, భగవంతుని ఆశ్రయించాలి. అంటే కర్మలతోనే తరించిపోతామన్న అహంకారాన్ని విడిచిపెట్టి భగవంతుని ఆశ్రయించు. ఇది భజగోవిందం అనబడే ప్రథమ శ్లోకం యొక్క వ్యాఖ్యానం. ఈ ప్రథమ శ్లోకంలోని ప్రథమ పాదం ప్రతి శ్లోకానికి మకుటంగా మనకు వస్తూ ఉంటుంది. ఒక విధంగా చెప్పాలంటే పల్లవి చరణాలతో కూడిన గేయంలా ఉంటుంది. పల్లవి ప్రతి చరణం వెనకాల వచ్చినట్టు ఇందులో ప్రతి శ్లోకానికి అనుసంధానం. నిన్న మనం సంప్రాప్తే సన్నిహితే కాలే నహి నహి రక్షతి డుక్రున్కరణే, దీని వ్యాఖ్యానమే మనకి సగం పైన సమయం తీసుకున్నది. అదే చాలా ముఖ్యమైనది. డుక్రున్కరణే అనే వ్యాకరణ సూత్రాన్ని హెచ్చరించి చెప్పడం కాదయ్యా, ఆయన నకర్మణ ప్రజ అనే భావాన్ని ఇందులో చెప్పారు. మొత్తం వేదాంత శాస్త్రాన్ని, సగుణ నిర్గుణ రూపమైన బ్రహ్మతత్వాన్ని ఇందులో ప్రతిపాదన చేయడం జరిగింది. గోవింద అనే శబ్దానికి సగుణపరమైన అర్థం చెప్పుకున్నాం, లీలాపరమైన అర్థం చెప్పుకున్నాం, నిర్గుణమైన తత్వపరంగా అర్థం చెప్పుకున్నాం. అది ఆత్మకు అభిన్నము అనే ఆత్మస్వరూపంగా కూడా గోవింద శబ్దానికి అర్థం చెప్పుకోవడం జరిగింది. ఇప్పుడు అక్కడి నుంచి మొదలు పెడుతున్నటువంటి అంశం ఏంటంటే, భగవంతుని భజించు అనేటువంటి మాట ఎందుకు చెప్పవలసి వచ్చింది మరొక్కసారి అడుగుతున్నాం. ఆయన తప్ప మిగిలినవి భజిస్తున్నాం కనుక. నువ్వు ఏవైతే భజిస్తున్నావో వాటి గురించి చర్చ చేస్తున్నారు ఇక్కడి నుంచి. సాధారణంగా మానవులందరూ తాపత్రయపడేవి రెండింటి కోసం, అర్థం కామం. ఈ రెండింటి కోసం. వీటిని పూర్తిగా తీసిపెట్టేయడానికి లేదు, తోసిపెట్టేయడానికి లేదు. జీవయాత్ర నడవడానికి అర్థకామాలు అవసరమే. ప్రవృత్తి మార్గంలో ఉన్నవారికి ఒక విధంగా అవసరం, నివృత్తి మార్గంలో ఉన్నవారికి మరొక విధంగా అర్థకామాలు అవసరం వారికి ఉంటాయి. అయితే వారి కామం అనేది భోగం కోసం కాకుండా ప్రాణరక్షణార్థం నివృత్తి మార్గంలో ఉన్నవారికి. కానీ ప్రవృత్తిలో ఉన్నవారికి భోగం ఉంటుంది, కానీ ధర్మబద్ధమైన భోగం కావాలి, ధర్మబద్ధమైనటువంటి అర్థం కావాలి. కానీ ప్రవృత్తి మార్గగాములమే ఇక్కడ ఉన్నాం కనుక ప్రవృత్తి మార్గానికి అన్వయించుకోవాలి అంటే ధర్మబద్ధమైన అర్థకామాలు సంపాదించాలి. ఎందుకంటే అర్థకామాలకు అంతేమిటి? ఎందుకంటే లోకమంతా ఇచ్చినా చాలదండి, అంత ఆకలి అర్థకామ తృష్ణకి. అందుకే చాలకుంటే లోకమెల్ల చాలదు అన్నాడు అన్నమాట.
As it currently stands, you have to have some type of emergency or other significant need for that process to take place. So there's quite a few unused visas in the family-based categories that are now being reallocated to employment-based. And as last year, as we saw a historic movement with the Visa Bulletin, this year we're going to see even greater movement. So it's really a great time to hopefully see the dates move aggressively. And then at the same time, you and I have discussed, we have potential H1B GC backlog issues that might be addressed in Congress to help alleviate some of the stresses we have here, also incorporating the aging out provisions for children and other requirements that are currently needed.
Okay, so I think Charles Oppenheimer had a conversation with the travel doc a couple of months ago, maybe not couple of 1 month ago. He explained, I think his expertise, the visa number statistics, and he given all information what will going to happen the next couple of months. Most of the H1 holders and green card holders are eagerly waiting for the May visa bulletin. As for the video, everyone expected is there any rapid change or is any skyrocketing movement in May visa bulletin? Visa bulletin out on yesterday, on Monday. So we see the good momentum for 5 months in EB3 is a good move in the last couple of years. So do you think the same, the 5 months we'll see the next couple of months? The fiscal year this year, we have the next 4 months, June, July, August, and September. Can we expect each month move 5 months? Each visa bulletin can be moved 5 months?
Really what you have to look at when we're talking about movement, there's a lot of analysis that goes into the equation here. Whenever we're looking at historically, how many I-140s were approved, what visa category they were approved. And so all that information is public, and you can analyze that information and kind of guesstimate how many people might file and how fast the dates might move. Now, some other factors are, incorporated. Not 100% of all the people with an existing pending or approved I-140 are still pursuing that, or maybe they're not with the same employer, maybe they're not in the United States anymore, maybe the I-140 was revoked for some reason. So a lot of the data is really useful as far as a guesstimation. I would think that we're going to continue seeing movement, depending on how many people have a pending I-140 during those times. But I can't say multiple months at a time, but we'll see progressive positive movement on the EB front moving forward through next fiscal year. And of course, when we get to the next fiscal year in October, I would anticipate the filing dates also to move quite a bit, into maybe even 2016.
Oh, by next fiscal year October, or you meant to say the end of the fiscal year?
Yeah. So the fiscal year 2022 actually starts October 1st, 2021. So that's the new year for the service, so the government. So, we could see, historic movement within one calendar year for the Visa Bulletin, obviously for the filing dates, but also the final action dates moving so quickly. And then if you add that with the possibility that this visa backlog, the EB visa backlog, could be addressed by either adding more visas available or somehow, incorporating, more per country cap or per country limits with the visas allotted, just minor changes like that could increase it even tenfold more. So it's really exciting.
Yeah, it's really exciting, the movement, and also events. Just everyone is expecting is the trend will go to the next couple of end of September this 21. So they can, we can see progressively each will might have the more than 3 months. So in this scenario, lots of confusion, because most of the H1 holder is downgraded to EB2, EB3 from EB3. So now, is there any chance to move in the EB2 category? Now we see the September 2010, but any big movement in EB2 category by September 30?
Probably not enough to consider refiling. I wouldn't expect it to move that much. So, the majority of people who filed in October this past year or November would be someone who was probably EB2 that had a priority date somewhere in 2012 or 2013. So when we're going through the process and your case is being adjudicated, the service utilizes the final action date on processing the actual case. So we have to remember the final action date is still at 2010. So for anyone who might have downgraded, there's still a little bit of time in there, before making the decision to do anything. Again, what I would say is, patience is key. Let's wait and see what happens the next few months. There's 2 pending immigration bills that have already passed the House that are now in the Senate. And depending on the debate on how these 2 bills go, there's something, I can promise you, something's going to happen with immigration, comprehensive immigration reform. It has to happen. It will happen. How much of that is going to happen is still what's key. On the side that's closest to, most likely to happen is going to be this issue with the EB backlog, children aging out, other provisions that, to protect highly skilled workers, things like this. And on the extreme other end, that's least likely to happen is going to be people who might currently have TPS, who might not have a pathway to citizenship. So there's a broad spectrum currently right now with proposed plans and what might happen. And on this end of the spectrum where most of our listeners are going to be concerned is, there's nothing that's a guarantee, but there's a high probability that this changes are going to take place.
Okay. Yeah, we've been discussing about this comprehensive immigration from last year. Hopefully, we will get more good news in coming weeks and coming months. Lucas, just one scenario. As for October, we downgraded it. Most of the H1 holders has downgraded EB2 to EB3. Let's say in general scenario, maybe is any chance? So if EB2 move faster, USCIS will ask. Let's say EB2 priority date move forward, but still EB3 is remain the backdated. So is there any chance USCIS will ask to, hey, you have the 2 I-140s. Do you want to? USCIS will give the option to utilize the EB2 I-140 or EB3 I-140 or something kind of.
You can always process this again, and it would be basically filing another I-140 at that stage if you downgraded in the traditional sense, and you would just in turn upgrade again. Now you have to remember your application was filed based upon the filing date authorized by USCIS in the Visa Bulliten. So if you have to remember what you currently have right now pending with EB3 to get your GCEAD, advanced parole, and things like this. You still will not have the opportunity to move in EB2 because those dates are still probably too far out. Okay, it's probably just a very select few people that were on the cusp from EB2 to EB3 that might impact this, and even still, the EB3 is still going to move quick enough to maybe you should stay course and proceed with that route, because the dates are in such. But with anything like this, you should always consult the attorney or anyone else who in a similar situation, or your employer. Find out what's going to be best for you, because depending on exactly what your priority date is and how fast things are moving, it might be in your best interest to stay put. Knowing your company history, maybe you work for a big company, they're not interested in doing too much movement, versus maybe you work for a smaller consultancy that wants to support you no matter what. So it really depends on your situation, what your date is, and other factors similar to that.
Okay. So, Lucas, just I want to discuss one more point here about the downgrade EB2, EB2, EB3. Still, the same topic is now the same topic is discussing everyone. While downgrade the I-140, do we have really kind of amendment or new petition? Each downgrade is a new petition, or is there any option to make an amendment to existing I-140?
There's always option to adjust depending on how the case was filed. So most downgrades, the safest bet is to utilize the previously filed labor, and what you're doing is you're amending the terms or downgrading. So whenever you downgrade, you're using the previously approved form petition, and you're basically selecting a different category that you would qualify for. So we see this more common maybe in practice with family-based petitions, because you can change places. You have to think of it as lines. So like in employment-based, there's 5 main categories. Your priority date is your priority date, for your employment, and one is a priority date for your family. So you can't utilize both in different categories, but you can move from one line to another within each of those categories. So it would require you refiling the petition, most likely on how it was the attorney handled the case.
Okay. Maybe we can get a clear picture when dates are maybe conflict, or maybe it comes EB2 and EB3 get the same who had downgraded process.
It just depends on how the attorney filed the case. That would, every case is unique, as you know, but we would have to make sure that, is this uniquely 2 different cases? Is it a downgrade? What is the circumstances with that?
Okay. It means whoever downgraded to EB3, if the same priority date comes under EB2 category. So if we want to go to the EB2 category, then we need to upgrade, right? Technically the word is upgrade to EB3 to EB2.
Correct.
Right?
So you have to remember your adjustment application is filed in this scenario under EB3. So since it's filed under EB3, your adjustment would have to be, associated with an I-140 in a different visa category. In this instance, EB2.
Okay. So, yeah, I stressed a lot of the same repeated question, because we see the good movement in EB2 and EB3 final action date. A lot of people have the same kind of questions they do have. And a lot of people got confused in this scenario, how they can handle and how they can approach to utilize the category EB3 or EB2 to get the green card as soon as possible without any issues.
I mean, I would just wait until the final action date moves to where it's within maybe a month or 2 months before you make any type of decision. Don't start planning whenever the dates are still 6 months out. I would wait, just see how the dates move, how fast EB2 moves versus EB3, and just stay the course until it gets closer. Also, since we're talking about green cards, I do want to change the subject slightly and announce that, U.S. CIS has announced that any cases that were impacted, that were improperly filed, are being accepted. You might receive a notification in the mail notifying you to resubmit your case from USCIS. Not everyone gets the notification, but some people have. If you do, and your case has already been resubmitted, disregard, it's just kind of a courtesy notification, but not everyone will receive, but pretty much all cases should be accepted if they're resubmitted from the cases filed last October and November.
Okay. So yeah, Lucas, we can step into the maybe I come back to this maybe Visa Bulliten. Just I want to discuss about the October 2020 Visa Bulliten and adjustment of status. It's been almost 6 months. By the end of this month, it's almost 6 months. The most of the Texas centers still they don't see any biometric letters issued. Here and there, we hear the Texas center is utilizing existing fingerprints. Is this true?
Yes. So, this is true for if they have your biometrics on record and it's within a certain period of time, they're utilizing previously collected data. So that is helping everything move faster. There's also, possible changes with H4 EAD to stop the biometric requirement, which would also help speed up everything as it comes to GCEAD and things like that.
Okay. Let's say you said that they are utilizing. If they are utilizing, everyone can expect get the directly EAD card and advance payroll.
I wouldn't say everyone. If the information's on file, then yes. Here recently, maybe 2 or 3 weeks ago, I had a client that their mother, they're a U.S. citizen. They petitioned for their mother, and she didn't go for biometrics or a visa or the interview for her green card. They just approved her, gave her a green card, and in the approval it says, at the moment. We're issuing the green card, and if an interview is required in the future, we'll call you in for that. So that, a lot of this is impacted by COVID-19, and, hopefully, the utilizing the records that are on file will help speed up the process. But, I know people who filed supplement J's who didn't have to downgrade. Pretty much all of those cases, they've received GCEAD. But all the downgrade cases, except for very few, are all still pending. So it's very frustrating, but hopefully the logjam will clear up here soon.
Okay. So you spoke about the supplement J. I have one scenario just to give me your suggestion. One H1 holder applied green card filing date in 2011, they got authorization card and advance payroll. But later they changed to another company, but still they did not apply the supplement J yet.
Mm-hmm.
So the dates are moved to the final action date. How they can plan to apply? It means by default, USCIS will get to them and request to the medicals or next steps, right?
Correct.
So they do want to apply supplement J right now, or how they want to look into this final action date without any supplement J till now?
Well, so what they want to do is go ahead and work with their current employer and maybe have all the documentation prepared for supplement J. And have that ready. Now you can't just the best practice is to either wait for an RFE or wait for your interview appointment. And one of two things can happen. An RFE can be requested for you to mail in the document prior to the interview, or they can issue the interview appointment notice and request that you bring both of those documents in with you. Most of the time when I've attended visa interviews, obviously this is before COVID, we would just always bring an extra supplement J with us if the person had changed employers, with the appropriate offer letters and things like this, and hand them to the officer. Even if they didn't request, we would always want to make sure that we hand them the most recent supplement J to have in the case file.
Okay. Let's say they will plan to submit the supplement J. How much time it will take for the approval? The general time, or?
Well, so after all this takes place, you have to remember, what if the dates retrogress or things move? So if the dates retrogress, the work stops on the case, and you have to wait for the dates to become current again for the final action date. So if everything continues the way it is, hopefully it doesn't, hopefully within a few months to maybe half a year, you would have the actual approval in hand. But it's really just, it's all about processing times and how long, certain officers take, or service centers are taking, or field offices.
Okay. So yeah, Lucas, we can go back to May Visa Bulletin. We are seeing the aggressive movement. So in this scenario, whoever applied in, let's say now it is February 2011. Let's say next couple of months it will move forward. Might be expected by mid of 2012 or end of the 2012, get the final action date. So we have the very just 4 months of time. Most of the H1 green card holders is downgraded to EB3. So we know that every visa bulletin move forward to 4 to 5 months or 5 to 6 months. Do you recommend to downgrade the I-140 make a premium process, or should they wait until get adjudicated downgraded I-140?
It just depends on each person's situation. If you're really getting that close, to these final action dates, I would recommend upgrading to premium. If you're concerned about maybe porting to another employer, going full time or something like this, upgrade to premium. If you need some resolution because you're unsure of what's going to happen in the future, go ahead and upgrade to premium. But it's something each person has to make a decision on their own. I know it's very important for this process to take place, but premium processing is still currently $2,500, so it is a little bit of money. That the expense there, so you want to balance everything out with what's in your best interest. But each person that has their own point of view, and by all means, the service is there. If you choose to pay for it, it's available to you. So there's no reason against doing it other than the cost and things like that.
Okay. So. In this scenario, let's say the dates are moved forward, but still we did not get the biometric. If final action date come current, in this scenario, how does it will work? The applicant should be wait biometric and first give the biometric, then after it will adjudicated the GC adjudicated, or?
So the I-140 is going to have to be approved. Obviously to have the GC adjudicated. We file cases for people other than Indian nationals all the time. So a good example would be if we have a Nepalese or a Bengali, we file the I-140 and the adjustments concurrently. And, overall from start to finish, it takes about a year and a few months. And that's when the final action dates are current. And it is a process. Again, depending on what service center has your case and where you live, is going to determine how soon or what happens with issuing the biometric. Now, to qualify for the benefit, which would be the GC, the I-140 petition has to be approved. And what the I-140 petition is doing is verifying that a relationship exists between the petitioner and the beneficiary. In this case, it would be a bona fide job offer for future employment, that the recruitment's requirements were met, and that no other Americans available for this particular job. And then you can move forward after that's approved with the GC, if that makes sense.
Okay. Lucas, just we can touch the one H4 and L1, L2, H4 and L2 biometrics. Do you see any progress, or do you see any updates for
yes.
H4?
So for these, especially for the EADs and the H4 and the L2s, there's been a lawsuit that was filed. I think we mentioned 2 weeks ago. It's been 3 weeks or a month now, and hopefully, we'll see progress. Hopefully by midsummer, that there's some resolution on this. Resolution would mean that if this lawsuit, survives the motion to dismiss, the government's going to file against it. And there's discussion on the merits about what, the issues are. The USCIS is probably going to negotiate at that point to maybe remove certain requirements for EAD biometrics, or H4 biometrics, or L2 biometrics, and revert back to the way it was, 3.5 years ago. And if that happens, that's going to help, speed up the process for not just people with those visas, but also anyone applying for like GCEAD or any other type of EAD that would require a biometric.
Yeah. Okay. Yeah. Thank you. Hi, everyone. If you have any questions, you can call to the conference number we provided in description, so we can address your questions, or else we can take a couple of questions and we can end up the show today. Lucas, do you have any additional information about adjustment of status and May? We already discussed in May Visa Bulliten. If you want to share if any additional information, you can share. Yeah.
I don't really have any additional information. I do have maybe some generalized information for H1s that I can share, if that's okay.
Yeah. So, yeah, you can share. Yeah.
So this last year, obviously, it's historic. We had the Newfield memo rescinded. We had this third-party offsite employment memo rescinded, and we've had pretty good track record over the past year of not having too many RFEs, of getting straight approvals. If we get an extension approval, it's for 3 years, and it's almost a 100% track record. So in the meantime, after we get these approvals, there has been increased administrative site visits occurring. And a lot of people are caught off guard when it comes to these site visits. And I want to remind everyone that it's very important that, if we have any type of contact from the government, we want to address it in a professional manner, and we don't want to be panicked. And, they do ask quite a few questions, and sometimes they ask to meet in person. It's always to your benefit to probably ask for contact information such as email, so the officer can request via email what documents you need. And that way you can, at your own pace, coordinate those documents and submit everything correctly, because we don't want to rush this and submit or say something that could be used against you. Maybe in the future, if you go for visa stamping, we don't want someone to say you misrepresented a material fact or you lied or something like this, when that's not the case. So we've seen these increased site visits occurring, and they're probably going to continue occurring in the near future. So it is kind of a hassle to go through this process, but we do want to make sure everyone's aware that to just remain calm, be prepared. There's no requirement that you have to meet someone like an officer in a Starbucks. There's no requirement you have to go anywhere with anyone. You can obviously, if they contact you via email or phone, you can respond to them, and always make sure you feel comfortable with whatever you're doing. So just respond in a timely manner and try and do your best to submit the documents they request, and that should be sufficient.
Okay, thank you. Lucas, here we can discuss a couple of questions. The first is very interesting, and yeah, you can share your maybe suggestion, maybe your thought on this one. So one of my friend, he's H1 candidate, he's working in some XYZ company. He got a mail, he opened the mail and he saw the letter from one of the law firm. It's saying that, hey, his name and his position mentioned that, hey, the so-and-so name and is a consultant from some XYZ company. Hey, we got your information. It's not a got information. We have your information. We want to analyze your labor payment, your LCA pay stubs. They want to analyze the payment history of the company, whether the company is paying well or not based on LCA. So here my question is really any law firm send a mail to some H1 holder saying that, hey, I want to analyze your pay stubs against their pay stubs?
No, and refrain from doing this. So it's usually a scam. And I'll tell you a story of a client of mine that happened probably about 2 months ago, that he's going through the process. He's from a different country, so his everything was current when we filed the adjustment, and his adjustment's pending, just normal. He has his EAD, and I think the root of all this is that our government was hacked, a few months ago, or maybe half a year ago now, and someone called him claiming that they had a ICE arrest warrant on his behalf, and he needed to send $1,500 immediately through gift card to this person. And he referenced a local police department, and these people are so clever, they're able to get this number to clone to make it look like the police department's calling. Okay. And he was panicked, and of course he sent the money. But if you send money in this regards, it's very hard to get back. So we contacted ICE on his behalf to inform them of the fraud, and we also contacted the local law enforcement where the person said they were a member of or calling from. So there's a lot of different frauds that are out there. Never release your information. And if someone comes up to you, and we live in a dangerous time right now, there's a lot of crazy people that are acting on crazy ideas at the moment, and they're attacking people. Like in Indianapolis, there's a lot of sheiks that were impacted by people with hateful ideas. You don't know what people's intentions are. Never go and meet with someone just because they say that they're with the government. They need to show you a badge. They need to show you a card. They need to have valid identification. So most importantly, protect yourself in the sense that don't just go to Starbucks. Don't just go and meet someone in a non-professional setting, because, in this day and age, how do you know who's, trying to rob you or steal from you or hurt you or anything like this? And always be skeptical if someone calls and has this sort of contact with you.
Yeah, here, Lucas, even I heard a couple of scenarios. It's really ICE agent will fly to the H1 holder location and call and ask to come to so-and-so nearby Starbucks or something. Is really happen? Or how ICE will behave if they want to do the inquiry on any H1 candidate, something? Will they go to the candidate, or they will ask to come to the office and they will investigate or be off of maybe any information?
Well, that's a good question. So typically, ICE is not going to do investigations. Okay, ICE stands for Immigration and Customs Enforcement. Okay, so if you're issued a notice to appear, which is in essence would be like a warrant, they're going to come and maybe arrest you or things like this. We saw a good example of this practice whenever Farmington University happened. And, ICE showed up at all 300 students' location and pretty much detained all 300 students at one time. Okay. ICE isn't going to just go and investigate on their own. There's other agencies that collect the data and information. So typically, FDNS is going to be the system that goes through and collects the information. They don't have any authority or ability to really detain anyone. For the larger issues that we have another agency called Homeland Security Investigations, or HSI, and they conduct a majority of what I would refer to as H1B violations from a company perspective. And, they're typically the most common way for our clients, we represent all sorts of immigration cases, would be as if someone was arrested for like drunk driving or theft or something like this. And then while they're in custody at the local level, they'll be referred to ICE at that point, and then ICE will process them. So that's typically the normal way of operation as far as things happening. Sometimes people will ask to meet in a Starbucks, but the people that do that are officers that are FDNS officers. They're not ICE officers. Okay.
No. Will it be possible, maybe USCIS agents to ask to come near Starbucks or something?
It's possible for them to ask, but I always, when I'm asked the question, what should I do? I would always suggest, you're not required to go to Starbucks or anything. Just, can you email me? I don't feel comfortable meeting you there. Can you email me what you need? Can we talk over the telephone? Obviously, if it were official business and they really wanted to talk to you, I don't know how ICE would operate in a Starbucks, so obviously they do request that, but you're not obligated to go to Starbucks with an officer.
Yeah, just I'm coming to the same point. If anyone in the same situation or scenario, what is the best way for the act?
The easiest way is to say, officer, thank you for contacting me. My name, like you asked who I am. This is who I am. My phone number is this. My email is this. My employer is ABC Company. Please send me an email of what you're asking me or requiring me to produce, such as like my payroll documents, my LCA, whatever it is. And just say, it's easier for me if you can email me a list of what you need. I'm here to help and accommodate you with whatever you need. I just don't feel comfortable meeting you in person at the moment. Things like something like that. It doesn't have to be a tense situation, just a very polite suggestion to move everything offline, so to speak.
Okay. So just we step back to the first question. Is any law firm is authorized to verify our H1 holder pay stubs, or whether the company is paying properly or not?
No.
Is no? Okay.
No.
It means yeah. When he said that, I thought he's a kind of a spammer or a scammer. So interesting point is his name is correct. Just a job description as a consultant, but it got his current residence address, but his H1 is an extension on last year, and that address was different. So if you want to correlate, or if you want to analyze how we got this scammer mail or spammer mails, so just we analyze the total is different what we given to the USCIS while applying to the extension, and what he got currently, totally different. So finally we thought is the scam. So just I want to bring today with you. So
And I'm glad you brought that up. There was a significant hack and loss of information, I think, that occurred maybe at the end of last summer, maybe early fall. And once that information is stolen, I mean, anyone can really access it, I guess, on the black market or whatever else. And yeah, I've heard all sorts of different scams. And anytime it starts sounding fishy, or some other odd request like that, don't just give all the information. Ask for credentials, ask for email to verify things, and then once you have that, you can easily reference your employer or your immigration attorney or any other attorney or someone else to help you out to verify if it's authentic or not.
Okay, thank you. Yeah, Lucas, I have a couple of questions, and after that we can close today's session. So this is about the October 2020 adjustment of status. The primary pre-audit date is 2012 November. They applied downgraded in 2020 October, but did not get any biometric yet. If the final action date become current in next couple of months, what can I do get biometric done faster?
Well, so you said it was a downgraded case, right?
Yes.
So they could probably go ahead and request premium processing for their I-140 that's pending, have that approved, and hopefully that would help speed up that process to, when the final action date becomes current, the only thing left to adjudicate would be the adjustment of status application.
Okay, yeah, thank you. So this is about Freedom of Information Act. Everyone knows we can get a copy from USCIS about I-140 copy. So he's asking that FOHA unable to locate I-140, though I have an original I-140 approved document from previous employer. Is rarely happen in USCIS. USCIS should have the one copy, right? If we request any given time, USCIS should provide a copy to I-140 holder?
Correct. Because in the sense that the difference between H1B and I-140, when a H1B, your employer petitions for you, they're the petitioner. They, in a sense, own the case. And the beneficiary, which would be the employee or the resource, they don't have a vested interest in the case other than it gives them permission to work. So it's really the employer's case start to finish, and the employee cannot request a copy of the file or anything else. Now, when you file an I-140 petition, you have both the petitioner and the beneficiary. As an attorney, we represent both parties equally, and USCIS treats both parties equally as well. So it's also your case, and technically, if you went back to the attorney who originally filed the case, if they should be able to afford you a copy of that file if you still have contact with that attorney.
Okay. But if in a scenario, if we apply for a FOHA, the USCIS is unable to provide the copy, then we need to reach out to the attorney, get one copy from attorney, right?
I would do attorney first, because attorney is supposed to provide you, copy if you request it. Now, having been almost 10 years since that probably was filed, or 8 years, I don't know if they would still have access to that or not.
Okay. So this is one of interesting question, Lucas, about the H4. The H1 we filled in April 2019 and approved in July 2020, and H4 applied in November 19, still in progress. It rarely happened, Lucas. It's been almost 1.5 years or something. It's still not adjudicated H4.
Yeah, I've heard of such delays. I mean, I would go ahead and reach out and file a service request, or see if there's any way we can make movement on the case to expedite this, because that's a huge delay.
In this scenario, the only one thing is raise a service request, or is any other process?
Well, first, what you would want to do is raise the service request so the service has knowledge of this issue. If after you receive the service request response and it's still in a pending status, you could at that point raise probably the most effective way of doing this would be filing a lawsuit for a mandamus action, which pretty much means I'm filing a lawsuit to make the government act for some action to take place on this pending case.
Okay. So, Lucas, I think I'm done today. Still, if you want to share anything else, what we discussed today's show.
Well, I think it's great to kind of get back to this format. I'd like to encourage anyone who's watching this live or who might happen to watch this after this airs. Please feel free if there's a topic you want to discuss, you don't feel comfortable maybe calling in or messaging us on the show, just feel free to email us and or message us on Facebook. And at the end of the day, this is a platform for the community. We want to provide accurate information and make sure we're addressing the needs and the questions that the community might have. And our success is your participation with this show. So we appreciate that, and look forward to more interaction in the upcoming shows.
Yeah, thank you. Yes, Lucas, we are encouraging to everyone participate in this show and get more information on US immigration. And if anyone has sensitive information, or if you want to discuss offline with Lucas, send email to info@bgimmlaw.com. So Lucas will address your question, or maybe he can suggest for the proper direction, get easy way. Yeah, I think today is pretty much a good information and very good news, and good news for the final action date. Green card. Eventually, July, August, June, July, August, September, we see the more skyrocketing movement. So be ready and act based on the situation. And if you have any questions, maybe anytime you can reach out to us, and we will try to provide as much as true information to your case. Yeah, thank you, Lucas. Thank you very much being today with me. So I'm done show today. We will meet next week, the same time and same platform, every Wednesday, 6 p.m. Central Time on Facebook Live and YouTube Live. Thank you very much.